Good morning, this is your Kelso Report for Tuesday, March 27th, and I'm your host, Clark Kelso. We have today a cert granted and a search and seizure case. The Supreme Court issued some decisions involving political question doctrine and securities law. Then we turn to the Ninth Circuit for alternative dispute resolution, foreclosure, and the California Court of Appeal have decisions dealing with health law and public utilities. We begin with a cert grant from the Supreme Court yesterday. A search and seizure case. The Florida Supreme Court held in Florida v. Harris that evidence of training and certification of a drug detection dog is insufficient by itself to establish probable cause for a search when such a dog goes on alert. According to the court, to demonstrate that an officer has a reasonable basis for believing that an alert by a drug detection dog is sufficiently reliable to provide probable cause to search, the state must present evidence of the dog's training and certification records, an explanation of the meaning of the particular training and certification, field performance records including any unverified alerts, and evidence concerning the experience and training of the officer handling the dog, as well as any other objective evidence known to the officer about the dog's reliability. The trial court must then assess the reliability of the dog's alert as a basis for probable cause to search a vehicle based on a totality of the circumstances. That's what the Florida Supreme Court held. U.S. Supreme Court's granted cert. I'm guessing they're going to reverse the Florida Supreme Court's significant expansion in requirements for establishing probable cause in the context of drug detection dog searches. Florida court got a little bit carried away there. Next, from the Supreme Court of the United States, a case involving political question doctrine. Congress had enacted a statute providing that Americans born in Jerusalem may elect to have Israel listed as the place of birth on their passports. Well, the State Department declined to follow that law, citing its long-standing policy of not taking a position on the political status of Jerusalem. When sued by an American who invoked the statute, the Secretary of State argued that the courts lacked authority to decide the case because it presented a political question. Both the District Court and the Court of Appeals agreed and dismissed the action. Well, yesterday the Supreme Court reversed with only a single dissenter, not a close case. The lower courts had framed the case as involving the courts sitting in judgment of the executive's foreign relations power to decide which countries to recognize. But the Supreme Court saw the case in, I think, simpler terms, as involving only the constitutionality of the relevant statute. The statute may, in fact, be unconstitutional because it violates the executive's foreign relations power, or it may be constitutional, in which case the executive is bound to follow it. Either way, the determination of a statute's constitutionality is a core judicial function, and the political question doctrine therefore does not apply. The court remanded so the lower courts could reach the merits in the first instance. Next, we have a securities law case from the Supreme Court involving a statute of limitations. Under Section 16B of the Exchange Act, as amended, a corporation or security holder of that corporation may bring suit against the officers, directors, and certain beneficial owners of the corporation who realize any profits from the purchase and sale or sale and purchase of the corporation's securities within any 6-month period. According to the statute, suits must be brought within, quote, 2 years after the date such profit was realized, close quote. Well, the plaintiff filed an action under Section 16B to challenge transactions that occurred many, many years after the 2-year period had apparently passed. The Ninth Circuit permitted the actions to go forward, holding that the running of the 2-year period is tolled until an insider files the disclosure statement that's required by Section 16A of the Act. The Supreme Court unanimously reversed, holding that this interpretation is clearly at odds with the text of the Act. Since the theory of liability under Section 16B is a novel one, the practical result of the Ninth Circuit's rule would be that many insiders who plausibly did not think they had any filing requirement at all would remain potentially liable for decades. The court held that the Ninth Circuit should have analyzed the case under ordinary principles of equitable tolling. And those principles include a requirement that a plaintiff have pursued his or her rights diligently and that some extraordinary circumstances stood in his or her way. The Supreme Court rejected the idea of a clear rule that says, hey, it's tolled until you file your disclosure. The Supreme Court remanded the Ninth Circuit so it could apply the equitable tolling doctrine to this case. Next we turn to the Ninth Circuit, a case involving alternative dispute resolution. The parties had entered into a production agreement regarding further development of the Chipmunks franchise. The agreement also contained a forum selection choice of law provision that any dispute will be brought in California state or federal court and governed by California law. The agreement further provided that any dispute arising out of the agreement would be submitted to a general non-jury reference pursuant to California Code of Civil Procedure 638. The plaintiff sued. Fox filed a motion to compel the reference to a referee and sought a stay of proceedings, which the district court granted. The plaintiff then tried to appeal. But consistent with the approach taken in arbitration, the Ninth Circuit held that an order enforcing a contractual reference to a referee is not an appealable order. So the Ninth Circuit dismissed the appeal. Next we have a case involving bankruptcy and foreclosure. The lender for real property that was subject to a stay in bankruptcy tried several times to hold a foreclosure sale, but each time publicly announced that the sale was being postponed to a subsequent date. The fifth time this happened, the lender sent a legal secretary down to the flagpole where foreclosure sales were frequently held, but the secretary did not publicly announce a postponement and did not announce a date for the subsequent sale. Instead, she simply asked several people who were in the area whether they were there for the foreclosure sale, and they said no. A month later, the lender held another foreclosure sale and was the sole purchaser. The Ninth Circuit held in In Re Kaluualisa that the postponement did not comply with Hawaii law and that the proper remedy was avoidance of the sale. Although this may seem like a hyper-technical application of foreclosure procedures to some, it is, I think, just another example of how the banking and finance industries tend to take shortcuts, and courts ultimately catch up with them and declare the shortcuts to be unlawful. Next, we turn to the California Court of Appeal for a couple of decisions, first involving health law. In California Association for Health Services versus Department of Healthcare Services, the state scored another judicial loss in the management of its Medi-Cal program. This time, the target was the annual rate review related to reimbursement of providers of home health agency services for the years 2001 through 2005. In the context of a petition for writ of mandamus, the 3rd District held that the department acted arbitrarily and capriciously by relying on out-of-date and irrelevant data in concluding that its rates were sufficient to ensure that Medi-Cal recipients had the same access to care in the geographical area as members of the general public from 2001 through 2005. Now, the basic problem facing the state over the last decade is that it has expanded the coverage of the Medi-Cal program without actually having the revenues to support the expansion. As a result, the state keeps getting itself into trouble with both state and federal courts when it tries to balance its overall books by reducing amounts paid to providers. But having expanded the scope of the program, there is no political will to reducing the scope of benefits. There's also no political will for raising revenues. And the result has been a persistent structural gap. Next, a case involving public utilities in San Francisco. Pursuant to a contract between PG&E and the City and County of San Francisco, PG&E agreed to transmit electricity generated by the city at its Hetch Hetchy hydroelectric plant to San Francisco, and PG&E agreed to distribute it locally. The contract distinguishes electricity to be used for municipal purposes and electricity to be used for commercial purposes, for which PG&E generally has the right to bill the end user. The Ferry Building, a property owned and originally largely occupied by the Port of San Francisco, was mutually agreed to be a municipal load building. However, in 2003, the Ferry Building was substantially renovated and its use was changed to mixed commercial and government, heavy on the commercial. PG&E contended that the Ferry Building no longer qualified as municipal load. In the published portion of its opinion, the First District in PG&E versus City and County of San Francisco agreed with the power company. Factually, I think the case was not even close. Pre-renovation, the port occupied a total of 82,000 square feet in the building. Commercial retail tenants that obtained their power from the city for a fee occupied a mere 500 square feet. Post-renovation, the building housed only 3,500 square feet for the port, and the ground floor of the building had been transformed into 65,000 square foot of retail marketplace. Total electrical power usage of the building almost doubled from 320,000 to 620,000 kilowatt hours per month. And finally, the master tenant of the building was no longer the port, but Ferry Building Associates, a private company operating the building for profit. In view of these material changes, the Ferry Building could no longer be classified as a municipal load building. The city was actually selling power to the commercial tenants at the same rate PG&E sold power to its commercial entities. So the practical result here is that the revenues from sales of the electricity to the Ferry Building commercial tenants now will go to PG&E instead of going to the cash-strapped city. And that's it for today's Kelso Report. I'm sure we'll all be watching and listening hard today to see what happens in the Supreme Court. This is the main argument today on the individual mandate. And perhaps we'll have some comments on that tomorrow. Have a great day in the law.